said, my lord, the matter will be taken up. The urgency is that, my lord, it's a 15 bigha of land. They are eviction order passed, paying only 8,000 rupees.
After the vacation,
After vacation, any date can be fixed. My lord, that is the date and only.
এটা দিয়ে দিন দিদি, কোনো 8 তারিখ বা 9 তারিখ,
Any date and time.
একটা ডেট দিয়ে দিন।
Any date and time. My lord, I am not pressing that lordship takes up the matter before vacation. Item 60 of the daily list.
9 তারিখ বা 10 তারিখ একটা করে দেবেন।
Lordship, great.
With your lordships, kindly, my lord, I was mentioning item number 293. My day before yesterday, I had sought for leave from your lordships and filed it. My lord, yesterday was the date fixed before the learned trial court, but it was fixed for argument. Learned trial court concluded the argument, has fixed Friday for delivery of judgment. Now, my lord, 20. My lord, it's a suit for eviction. My prayer for, my lord, amendment of my written statement has been rejected.
Why have you come so late?
My lord, because it was rejected on 12th of May. We
Why
obtained.
did you file so late? Amendment.
My lord, 16th we got the certified copy. My lord, that was the.
Did you file so late your amendment application? Why do you file?
No, my lord, we
That
came to
argument
know
of-
from some evidence. But from some evidence of PW1, we came to know about the fact for which the amendment of the written
When
statement.
was the
But
PW1
could it be upgraded, because day after tomorrow is the
Highly,
date
I
fixed
don't know,
for
because,
delivery of judgment. It is appearing in the
before
list.
the vacation,
Any time may be fixed. My lord.
to be mentioned a din.
Yes, yes, that's better.
But it's a date fixed for delivery of judgment is,
I'll try, Mr. Das. I don't.
but kindly, my lord, kindly, it's appearing in the list 293. Kindly.
My lord, my lord, may I mention one matter? My lord, is applied for certificate copy. Leave to give.
Leave to file without
Another
certificate.
copy.
My lord, I am carving for leave, filing a civil revision without certified copy but with server copy.
Your lordship,
When was the order passed?
Order passed on 3rd January 2026.
Why till now you have not been able to get certified copy?
No, my lord, client was quite ill. That's why he can't apply for certified copy.
No. Apply for certified copy. And
My lord, certified copy has been applied, but
when was it applied for?
applied for 24th February.
24th February.
Yes.
Very well. Diye din.
My lord, may I be permitted to mention for
Leave to file without certified copy.
your lordship may be permitted to mention for inclusion in the list that matter is supposed to be given on 23rd of April.
Maybe.
My lord, another one is for inclusion.
Said, please write your grounds and give it.
My lord,
Don't make me say everything, every day the same thing.
my lord, may I be permitted to mention one matter, my lord? My lord, there is a suit, my lord, which was filed by the other side, my lord, and then that suit was abandoned on the so cause action. Another suit was filed, my lord, and the fact of the first suit having been filed, pendency of the said suit before the other coordinate bench was, my lord, suppressed, and the suit has been filed, my lord. I had filed one application under Order 23, Rule 14, my lord. But I had relied upon numerous judgments, my lord. Nothing has been considered, my lord, a grossly
Very
non-speaking.
well. After the vacation,
So, my lord,
I'll take it
my
up.
lord-
Nothing before the vacation, nothing is.
My lord,
going
actually
on.
tomorrow is the date, my lord, when the
Oh,
trial
tomorrow-
will be
next
proceeded.
date I'll hear it. It's not that urgent
My lord,
that it is.
may I have your lordship's leave to mention, my lord, today, my lord, extension of interim order, my lord, will, it is near 4
it,
PM. My lord, difficulty is, my lord, today is 3:30, my lord, by ILS. My lord, our interim order will expire.
Very well, then
470 to
3:30 আছে
470.
ওটা, if you can bring your other side at 3:30, I'll take it up.
3:30, I shall
What
give
is the
notice.
problem? Tomorrow it will be extended. Why are you so worried about interim order? Don't mention unnecessary things. Please.
Item number 294 yesterday it was filed with your lordship's leave. It's appearing as item number 294. Mr. Mojumdar is leading me with that
Visitation of a father
visitation of a father.
by a mother of his son. কালকে দিয়ে দিন, upgraded করে দিন।
294.
Your Lordship, this is a civil revision that has been filed in the month of March 2026. Your Lordship, it is in the monthly list of May.
What do you want?
I want listing in the
Give
daily
it,
list.
give it.
Out
Give it, write your grounds of urgency. Don't
out of extreme urgency, item 462 of monthly.
write your grounds of urgency and give it. Mr. Bhattacharya, you are there every day. I say the same thing. Please write it.
One thing, my lord, yesterday when argument has started, my lord,
Can't
but
be helped.
Thursday will be argument when the judgment will be pronounced, my lord.
You give
If I kindly makes it,
write it. If your grounds are satisfactory, I will do it. Otherwise,
Item number 219 of today's.
sir, write your grounds of urgency and give it.
Expeditious disposal by
Expeditious disposal can wait.
custody of a child. My lord, may I be permitted to mention a matter for non-prosecution?
Non-prosecution দিয়ে দিন।
Deeply obliged.
লিস্টটা কল করে দিন।
My lord, I appear for the opposite party. I'm being led by Mr. Rajarshi Datta. He's supposed to be online, but if he isn't, I'll move it.
My lord, I am there. My lord, I am there, my lord. This is appearing as to be mentioned, my lord, because it has been assigned before your lordship. My lord, we agree to the, my lord, order which has been prayed for in the, my lord, civil division. Matter can go back to the state commission, my lord, for hearing, my lord, on the section 5 application.
So it is not that simple.
It is akin to withdrawal, my lord. We are accepting their final prayers. There is nothing more to adjudicate. We are accepting.
I am
their-
the petitioner.
Yes, but whatever if you have
Yes.
for something and
Yes.
that is being agreed to,
No,
what
that
more
is
can you give?
because that was simple in that at the time when the civil revision was filed, Millets. Thereafter, Millets, your lordship has already dealt with a matter concerning both the parties before your lordship, Millets. Regarding this Damodar Valley Corporation, Millets, Bharat High-Tech Cement, that cement factory, Millets.
That state commission matter.
Yes, Millets, that is the same. This is the tertiary offshoot of the same matter. Now the issue is they are presenting it so simple, Millets. Their intention is to do a matter before the National Commission, which is fixed day after tomorrow, before the National Commission. Because the National Commission has, by an order, indicated that it will not proceed unless this is disposed of. Now they are agreeing to it. What has happened is there was an interim order passed in this matter. Alleging contempt of that, even after a stay passed by this order, they proceeded before the State Commission. Against that, a contempt application is pending, Millets. That is not tagged together for obvious reasons.
Here you have prayed for setting aside of 2 orders.
Yes.
What are those 2 orders?
Plus the 2 orders are orders which were passed by the State Commission in a appeal filed by DVC without issuing notice on the Section 5 application and entertaining the main petition.
And I'm saying those are bad orders.
So he
Set
says
aside.
no,
What is what has contempt got to do with this?
I'll tell
They're just
why.
trying to drag the matter
Very
so
well.
that it is
At
not
to be
heard.
mentioned stage, I cannot hear it tomorrow.
Yes, no, Millets, kindly do not then keep it tomorrow.
No,
Mr.
tomorrow.
Kindly
Mr.
keep it
Chatterjee
tomorrow.
is leading me in the.
So they are agreeable to
Yes.
something and you
No,
want
Mr.
to
Chatterjee is
explain
leading me in the
Millets.
matter. Millets, kindly have it after 8 minutes. Nobody is going
No,
to.
no, they are just trying to drag the matter.
What
my
is
lord. I'm
drag, Millets?
accepting
The
them.
matter is pending since 2024 Millets.
What
I am only asking after vacation, after 8 Millets, kindly keep
their
it.
only intention is that nothing happens before the NCDRC.
Then
On 22nd.
on 8th I'm keeping it.
Yes,
Let
Millets.
us see what
After 8. Millets, after 8, 8 is the opening day.
Tomorrow, my lord.
This nine.
Grateful. No, will it be a lot of pleasure to call for the contempt file also, Millets?
Nothing.
Very
This has been assigned. No pleasure in calling anything which has not been assigned.
Very.
Much obliged.
Grateful, my lord, grateful.
Appearing on behalf of the bank's lordship, I'm
But I am leading.
lordship, my counsel
I'm
appearing.
leading at a minute.
Mr.
I'm asking for a short passover on my ground, my lord.
Very well. Pass over. Pass over.
I'm asking for a short passover, my lord. Kindly,
Yes,
my lord.
pass over.
Thank
Granted.
I'm for the petition. This is the matter which married sister filed against the brother and mother primarily. Because when she came to know that her portion of share is going to sell out by the
But
brother,
what have you challenged here?
I am challenging an order by which an application under section 94C has been turned down.
It is in the nature of an order under order 39 rule 1 and 2. It's an appealable order.
94C.
Yes.
That
94C will be in accordance with the rules. Rules is order 39 rule 1 and 2. Appealable order.
leave to take back the certificate.
Yes. This revisional application
Yes. My lord, I am for petitioner.
Yes. Opposite party?
Opposite parties. Opposite party is absent. My lord. Today is fixed for order.
Yes, he was supposed to bring a copy of the plaint.
Yes.
And
Yes. Yes, my lord. I am providing.
where is he?
उसमें लगा हुआ है.
Call him. Call him. Pass over. Call him. Call him. Tell him court is waiting for him. He took time and then he will not come. Call him. Yes.
Lordship, this is, we are for the, Lordship, the defendant petitioner.
I will do
Lordship,
that.
after the conclusion of
Wait,
the
Mr. Mukherjee.
trial,
Please wait. What happened yesterday? You said your case was there for argument yesterday.
oh, yesterday, ki wajah? Today is the argument. Before the-
I'll do this. I will modify the order. It will remain as an exhibit for the purpose of the court to apply its minds later. I will delete this observation that only in case of, since it is below rupees 100, therefore it will be admissible in evidence because of it being not registered. That portion I will delete because that is not correct. Even if it is below 100 for certain documents in terms of the Registration Act, registration is mandatory. It is not about value. He will consider the appropriate evidentiary value at the time of final adjudication of the suit upon hearing the parties. That is the law. You can see Shantilal Pachal's case, 2001. See 2001, 3 SCC, page 1.
Lordship, so we, Lordship, we,
The law, whenever an objection is raised as regards admissibility, the court is not powerless to mark it as exhibit, postpone the decision at the time of final adjudication. That saves time. That is the law. So the practice
yes,
that
now,
has been
Lordship,
followed by the
we relied upon one.
for the court to complete. The practice that has been followed by the court is absolutely correct. It need not decide the admissibility at this stage. At the later stage, when it hears the parties, it is always open to the court to decide that, and that has been laid down by a 3-judge bench of the court. In Shantilal Pachal's case, you can have it googled on the mobile immediately. 2001, 3.
2000, my lord, 1.
2001 SCC. 2001 volume 3 SCC, page 1.
2001.
Lordship, this is, Lordship, in respect of that, Lordship, documents, Lordship, I have relied upon one judgment.
You have relied on a judgment which will be considered at the stage of final adjudication. Why do you want the stage of the objection to be decided now? That is what exactly the Supreme Court said can be
Lordship,
postponed.
kindly record that this Hukumnama, unregistered document, has no evidentiary value.
No, I
Lordship,
will not record that. The court will record that. I will say that marking of exhibit will not preclude the court from deciding the evidentiary value at the time of final adjudication.
time
That is the law.
Rightly pointed out. Lordship, rightly.
And Lordship,
You come back after half an hour. You please go through the
No,
judgment.
Lordship, only one thing. Lordship, this, so for the,
Necessary to
no,
waste
so for
time,
the,
cite so many
today is the
judgments.
fixed up argument. I am not on that. Lordship, so far the Hukumnama exhibited document is concerned,
I will not
we have
decide
got
the evidentiary.
cross-examined them.
I am not going to decide the evidentiary value here. That is for the court to decide. Court has postponed it, rightly postponed. So far as the observations are concerned, that merely because it is below 100, therefore it can be admitted into evidence. That observation I will
Lordship
expand.
is absolutely correct.
Yes.
But so far this document which has been exhibited already as per your Lordship direction, Lordship, I have not get a chance to cross-examine on the basis of the exhibit document. So Lordship, let there be a, Lordship, the liberty may be given to cross-examine.
What liberty to cross-examine?
In respect of the exhibited document.
It was marked X for identification. Therefore, it was definitely tendered in exhibit. What are you talking, Mr. Mukherjee?
So identification,
tendered,
as it is not exhibited document, so I had not cross-examined. So Lordship, kindly fix a date for cross-examine only in the issue of
pray before the learned trial court. The procedure which has been followed is correct. Why did you not cross-examine? Even if it was marked X for cross-examination, your
Because
the
it wasn't
identification.
exhibited.
So what? So what?
Look,
Who
as
says
these
that-
documents is not exhibited, I have not cross-examined this person.
It was marked as for X for identification. You could have.
Only
for-
one day, Lordship. This is the
I'm
best.
not going to turn the clock back. You go before the learned trial court and do it. लिखे नहीं the Sir, I have said no means no. Follow the system.
Lord,
Can't barge in any time and mention.
Lord, the matter regarding to determination of my Lord Justice Sharma, just now this has been passed.
Please wait.
Lord, the
Yes.
Yes, but I wanted the plain.
Lord, kindly pardon me. If I am not wrong, on the last matter, my lord is wanting that judgment passed by Justice K.T. Thomas, perhaps. That is, all the documents has to be, my lord, marked, but
Yes,
not
Shantilal
exist.
Panchal.
Yes.
Shantilal Panchal.
Yes.
No, but the other judgment that I was referring to was of Justice Lahoti, where he has said what are the stages of taking objection. When a document is to be marked as exhibit, when to be marked X for identification,
for
stages are there.
Aye.
Likhen in. Itate likhen in. I am dictating this.
As your lordship is there.
Likhen.
May I just say one more? Main point
নাম
It is
কি হবে? নামটা চেঞ্জ করতে হবে। আরে আচ্ছা, লিখে নিন, একদম উপরে লিখে নিন, একদম উপরে লিখে নেবেন।
is the additional evidence. My lord can add. I'm grateful. My lord.
107 is also there,
Yes.
but you'll have to amend it.
Yes.
First amend the plan, because otherwise,
Otherwise, I'm grateful.
chalo, next.
Your Lordship, I'm appearing for the revisionist. I'm being led by Mr. Moinak Bose. I'm seeing a short pass over, Your Lordship.
My Lordship, I'm for the opposite. I'm also being short.
Next. Next, call for next. Other side is there. Call for them 3 ta.
I appear for the opposite party, my lord.
Revisional application. My point is that for any procedural order, mandatory deposit as it is conferred under section 18, subsection 1 is applicable or not. The crux of the matter is that my learned friend clients has served a notice under section 13.2 followed by section 13.4, against of which I file an AC application under section 17 registered before DRT. In that DRT applications, I filed 3 interlocutory applications. 724, 725 and 726. 724 in respect of sale notice and 725, that is subject matter of this revisional application, where, my lord, I asked for that bank has lodged one scheme of OTS that was prevailing. I'm a MSME unit. The scheme was lodged by bank stating that the customers whose account has become NPA dormant and NPA amount below 5 crores are entitled to get such scheme of one-time settlement. And that scheme was non-discriminatory and non-discretionary in nature, NDND scheme. And accordingly, I asked before the tribunal on the first instance, I want to settle this matter. Tribunal says that, yes, you can go for that. And accordingly, I made a pre-deposit of 12,50,000. And that is, my lord, kept with the record of the bank. Subsequently, I filed an application asking for, since the scheme is prevailing, I want to avail that scheme through which the account can get settled. In that interlocutory application, the learned DRT holds that OTS is not mandatory. It is the discretionary power of the respondent bank. Therefore, my IA application dismissed. Against that IA, I prefer an application before DRAT stating that since the scheme was prevailing and it was lodged by the bank itself, and I am entitled to avail that scheme. And accordingly, I filed an application asking for waiver of that fees, since the appeal is not against any order touching the main claim under section 13.2. It's a purely a procedural order. But learned DRAT holds that since section 18 subsection 1A 1 says that any applications, so you are fallen under the category, you need to deposit 50% of the claim amount. So I will not give you any exemption to that. Against of which I beseech your lordships in this applications.
Why do you say it is a procedural order?
Yes. For that, my lord, your lordship be pleased to come to my second volume, the prayer portion there at 178. The application.
Yes.
178.
178.
Second volume, 178.
Yes, 178.
Yes. Well, in the prayer portion, 184.
Yes.
For direction on the bank to send or issue the principal OTS approval annexed with the circular being number such and such, or implement the circular dated 27th July 2000.
You want your debt to be settled in terms of a particular circular of the bank. Now, if you want your debt to be settled in terms of a particular circular, and that has been refused by the DRT, how can you say this to be a procedural order?
My lord, reason being, my lord, they made a claim under section 13(2). I am not challenging that amount.
Of course you are. In a sense you are. If the bank settles at the OTS rate, will the same amount remain for settlement? For dues against you is X. The bank settles at X minus Y. What happens to the debt then? The debt is restructured to the extent of settlement. It is not a procedural order in that sense.
My humble submission would be that the proposal of the settlement was pending since long.
Very well. So what has the DRT done? What is the order impugned before the DRAT?
DRAT says that pre-deposit is required.
Yes, because this order, how can you say it is procedural?
Your lordship, can you see that
procedural orders will be, say, refusal to allow amendment, refusal of adjournment, cost title amendment. All these are procedural orders.
And my humble submission.
Addition of party.
My humble submission would be.
This is
I am not asking for a direction.
You are
directing the bank to send the issue of principal OTS approval.
No, either send or issue principal OTS approval. So you want an approval from the bank. You want a direction from DRT to the bank to approve your OTS. So that means restructuring.
On the earlier occasion also, on my instance, DRT has passed an order directing for settlement.
Very well, that is separate. That is, I am not concerned with the merits of the DRT order as a
No, I am also
wrong, maybe right. But I am on the aspect as to whether this kind of order can be said to be procedural. It has to be related to the procedure followed by the DRT, case management, procedure. That is different.
To that effect, my lord, Sunshine Builders and Developers versus HDFC Bank Limited. One is a Supreme Court judgment, my lord. I have citation of Monupatra. Monupatra ACOR 37303/2025. My lord, over here, my lord, relevant paragraph starts from paragraph 11. We take notice of the fact that securitization applications filed under section 17 of the SARFAESI Act is pending before DRT. In the said essay, which is pending before DRT, 2 interims applications were filed, being IA number such and such, respectively, for implementing the auction purchasers in the securitizations applications and condonation of delay in preferring such applications. If such an applications was
this is procedural in effect, because addition of party, I just said addition of party, condonation of delay, limitation is always procedural law. Delay condonation.
My humble submission before your lordship is that procedural order, does it 100% means that any order that is relevant with the merit of the case, or does it touch the subsequent portions of an applications that is pending before a tribunal or court?
If this order had been, if this application had been allowed, what would have happened?
Well, the bank will consider.
And what has now happened then?
Well, right now,
even now the same order is there. The order which you have challenged before the DRT also says that the bank will consider. This also, if that be the case, then you are not an aggrieved person. Both ways, it is difficult, Mr. Banerjee. If you say that that is what you are wanting, then in that you cannot fall under the bracket of aggrieved person, because you have to be a person aggrieved for the purpose of preferring appeal. Then your appeal is, the bottom of your appeal is knocked off. If you say this, if you say that you are asking because that has been granted, if you say that you are asking for approval, then in that case, that prima facie has the effect of restructuring the loan. So which way you want to go? That way, then your appeal goes. This way, you become liable for pre-deposit.
Well, only
prima
one,
facie,
only
subject
one,
to hearing.
only one clutch point is that if your lordships relies on, my lord, the subsequent paragraphs, that is paragraph 15 of this judgment, any order should be given some meaningful interpretation. Should any and every order that may be passed by DRT is sought to be challenged by the subject of pre-deposit.
Yes, that was a prima facie observation by the Honorable Supreme Court. The Honorable Supreme Court has not yet laid down the law.
My lord, well, my subsequent argument would be, my lord, pre-deposit means, my lord, an vast amount. The claim amount was 1 crore. So if I, কত টাকা ছিল 13 এর একদম 13 এর claim amount 4.5 CR. So
that you are entitled to convince the DRT to bring it down from 50 to.
I tried to.
You from 50 to 25. It is up to you. That is the,
I tried to. If
that is for the satisfaction of the DRT. I can't impose my satisfaction on DRT. DRT. It is for DRT to be satisfied.
What DRT holds that? DRT stand in a way of, my lord, Narayan Chandra Ghosh judgment, stating that
Narayan Chandra Ghosh judgment does not say that DRT cannot exercise its power to scale it down to 25%.
Here, DRT says that I will not.
What do you want? You want me to say that it should be completely waived, or you want a chance to go and
asking for complete waiver?
Then
I am not asking for.
If he wants the DRT to exercise further discretion, let him go and convince.
I'll just indicate why, apart from the judgment that he's played, I'll indicate why that's not applicable anymore. That I should have addressed your lordship first, my lord, because this judgment, my lord, does not lay down the law.
Let us not go about the judgment.
Very well.
Be on the facts. If he wants an opportunity to, if he wants an opportunity to further go and convince the DRT to scale it down, what is the problem?
It'll go beyond the scope of the waiver application.
How?
Because the waiver application does not
give me 50%.
No, waiver application does not say 50 to 25. Waiver application says that it's an interlocutory order. No pre-deposit is required.
That is the base that he has asked for. Now, something more than that he's not asking.
For 50 to go down to 25 within the mandate,
subject to the DRT
discretion of the court. But that discretion would be, my lord, not exercised.
That is for neither for you nor for me to decipher.
No,
it is for the DRT to decipher. If the DRT wants and he has an arguable case, suppose he can make out that case. What is the problem in that?
Lordship, only here's my 30 seconds on this, my lord. I am not saying that I'll decide it. I'm not saying that 227 court can decide it. It's an absolute discretion of the DRT as far as the point. Satisfaction, my lord. Now that satisfaction, my lord, has to be exercised not in a limbo, but in the factual circumstances. Now the factual circumstances, my lord, will be meted out of the waiver application. As on date, as we stand before the revisional court today, the waiver application does not make out that case. So even if today
application makes out a case of complete waiver,
yes, not for 50 to 25.
Very well. So if it makes out a case of complete waiver, then it can certainly make out a case for 25 also if the DRAT is satisfied.
In my respectful
The-
submission, my
if
lord.
if I say somebody that I will pay 0 amount, and then I say that no, okay, I'll pay 25 rupees. Does it mean that 25 rupees I will not pay was the meaning? I will say, I was saying that I will not pay anything. Now, if I say that I'll pay 25%, I have bettered it. Where is the bar?
But slightly distinguishable in these facts. I'll indicate it. Lordship, here's me, my lord. To my lord's satisfaction, Lordship allows me to make that submission. If I go back, but Lordship will give me that opportunity.
Only before the vacation will be.
I understand. But Lordship only hears. I'll just take, my lord,
Just
one.
for the sake of arguing, if you can argue, you argue.
Oh, no.
But
I'll take 1.5.
something which is substance and
Yes,
sense.
I will do
sense.
that. I will do that, my lord. Whether it's 50 or 45 or 30 or it goes down to 25, my lord, what's the factual? And there are an array of judgments, and this I don't have to tell you, Lordship. Lordship has, my lord, done this, my lord, throughout. But 50 to 25, that difference, the situation that has to be demonstrated before the court would not just be on the merits of the case. It would also take into
Very well.
account
He had
financial
not got
hardship,
that
all of those
opportunity
facts.
because he was arguing something else. Suppose
But
he brings
here-
before the DRT some material to show that yes, this is what he is
So
entitled.
he has to come by way of a fresh waiver application.
May come.
The present waiver application doesn't go.
He may amend his favor application.
He might,
may
but
amend it.
today that waiver application's been disposed of.
Very well, that can be revived because that is being considered here. If that is possible, that can be done. If you say that is impossible, then in that case it is different. If he wants to make
If your
an
lordship is
amendment-
of that opinion, anything further I submit, my lord, would just be for the sake of it. I'll be wasting my lord's time.
No,
If your lordship is
I have not formed any opinion.
No, I'm not saying that. I'm saying that if your lordship is of the opinion that they'll be granted the liberty to amend and go back and make out a fresh case for the DRAT to exercise its satisfaction afresh, well, then I can't stand in the way of that. Then I can. 227 court has the power. I cannot, my lord, argue.
The thing is that then I'll make an observation that the essay will not be stalled for this.
Yes.
This essay will continue.
His essay is already there. His essay, my lord, anyway, he's not asking for a stay. But today his appeal, the appeal cannot be commenced because he has not paid that 50%.
Yes. So till
He's
such
not
time
paid
he
that.
doesn't.
So if he
yes, show me your waiver.
Yes. My lord, may I just, my lord, take your lordship, my lord, to the supplementary affidavit that they have filed. Supplementary. My lord, this is at page number 5 of the supplementary affidavit. It's a 2-page application that they make out, which is why I was saying that the case of 50 to 25, my lord, it's not made out even prima facie for your lordship to exercise 227. Lordship has found, my lord, page number 6, my lord, it starts. 5 it starts, 6 is the pleadings.
He
I'll
wants
just read.
complete waiver.
Complete waiver on the point of an interlocutory application. And that law, my lord, he shows has now been overturned.
Yes, that
Justice
is right,
Partiwala's judgment
Mr.
is no
Banerjee.
longer in vogue.
Where is your case made out in the waiver application? Nothing
My lord,
has been written.
I state that when paragraph 4, that therefore it is submitted that appellant is entitled for waiver of pre-deposit
What? Mere
under section 18.
That is why the DRT has said, since you have not brought any material, therefore 50%, because that is what the DRT can do. You have not made out your case. I mean DRAT. You should have made out a proper case for waiver then.
My lord,
If you don't bring material before the DRAT, there is no fault in DRAT. What will the DRAT do?
my lord, my humble submissions would be that in that, perhaps, my lord, it was not happily drafted, a reason was not brought for, but I personally argued this matter, my lord. I impressed the court, the reason being that the scheme that was framed by the bank, and in neither this way or that way, I was entitled to get that benefit. And such benefit that was not granted on the face of it, it would have been considered.
That is on merits. That is on merits. That I'll not be considering at this stage into 27.
That was before, my lord, the tribunal.
Whether your waiver application has been decided rightly or wrongly. I don't find any error.
What I want that, my lord, on the very face of it, my lord, it said that my waiver application is dismissed.
Yes, rightly.
So, my lord, the discretionary power, my lord, is
because you did not give material to exercise the power. For the DRAT to exercise power, to reduce it from 50 to 25, you should have brought something on record to show that, yes, this is it, reduce it. You don't have anything to show.
To that effect, my
Merely
lord.
because you go and say that you grant me waiver, I'm entitled to waiver will not do. The DRT is bound by the statute, so are we.
But my lord, discretionary power is there, my lord, to consider this.
Discretion cannot be exercised in vacuum. You have to give them material to satisfy the to be satisfied that yes, where is that material? I don't
Well,
have
the
anything.
If my lord, that is so, my lord, then my submission was, and rather my submission would be before your lordship is
You
that.
can argue it on merits. Yes. What is your response to that?
Yes.
He says it's a procedural
Very
order.
well, my lord. He's shown a judgment of Justice Pardiwala. I'll address it right now. Well, I'm carrying the judgment. If your lordship looks at the judgment, Justice Pardiwala does not enter, because I'm using the judge's name because he's the one who dictates the order. Well, he does not enter
Say
into
Supreme Court. That is better.
Yes, I'm sorry. Well, the Supreme Court doesn't. Well, I'm carrying one copy. Well, it'll be slightly same judge.
He has given it.
Yeah, I'm just carrying this copy. It'll be easier to show the paragraph numbers if your lordship kindly allows me, my lord. Well, he does not enter into the merits. Lordship just takes up paragraph 15. The judgment gets overturned, and how I'll just indicate. Paragraph 15, if your lordship looks at, we are of the view, of course, prima facie. Yes. Then he remands the matter back.
Supreme Court's judgment can't be overturned. Why do you say overturned?
No, overturn, my lord, the factual, I'll indicate how, no, very well, my lord, lordship allows me to rephrase myself. He does not enter into the merits. The judgment is remanded back to the Bombay High Court. The Bombay High Court division bench holds that a Section 5 condonation application is not a procedural order, distinguishes, lays down the ratio, and says that the difference that the Section 18 authority has to exercise, the distinction is whether the order is procedural or whether the order decides a right which is between the parties. Now, the right that is, and they file a fresh SLP from the division bench order, which is passed in February. That gets dismissed in the month of March. So, which is, I'm sorry for the word that I used, but it's not overturned. Now that this judgment does not hold the fort anymore in the facts of sunshine. In the facts of sunshine, it doesn't. Because now in the same fact, it says that it is not a procedural order. 50 lakhs was directed to be paid. But because it was a residential property, the timeline has been extended now to make that payment. But that's on the facts. But that judgment also I'm carrying, if your lordship wants, my lord, I can show it's paragraph 40. One paragraph, I'll not show more than that, my lord. Just one paragraph on the merits. If your lordship has called upon me to address, my lord. Lordship takes up directly, my lord, page number 39. Just two paragraphs I'll show. Page number 39 of 53, my lord, paragraph 40. Next, let us ascertain whether lordship has found, my lord.
Yes, this is about the scheme of the act.
No, my lord, this is, if lordship looks at the first sentence, next, let us ascertain whether the common order passed by the DRT in the present case is a mere procedural order and not a final order, and whether as a result thereof the provisions of pre-deposit are not attracted. In order to properly appreciate the submission, lordship takes, my lord, the various sections. The finding, my lord, is at page number, my lord.
My lord, what was fallen from your lordship is, my lord, absolutely correct.
This is not
that
a procedural order by any stretch of imagination. If your lordship is satisfied on that, I don't have to show this one. It's otherwise not. So, my lord, OTS proposal, whether your lordship has rightly pointed out, whether the money that he pays after the OTS is considered or not considered, that is a subject matter, my lord, which goes directly to the root of the claim.
My lord,
It's an adjudication of the rights.
That is correct. But the thing before your lordship is that, my lord, what I am visiting your lordship, my lord, that power is vested before the court or tribunal.
Did not provide enough material for.
If it is not on person, my lord, I'm thinking about, my lord, the extreme things, my lord.
You should have gone before the DRT and said that now I have this material, please reduce it.
My lord, later liberty be given, my lord, to reapproach before the tribunals. Otherwise, my lord, my difficulty is that for such an interlocutory applications, whether that is also.
But now the order is passed. It can't be set aside. That is again a problem. DRT will not be able to review it. On what ground will it review it?
That power the DRT doesn't have.
That
He
power
can't
is
go
not
on.
there.
It's a
So
feature of statute.
You should have given that material. And even against interlocutory orders, pre-deposits are to be paid. That is settled by Supreme Court in 2020. I think Rajat Infrastructure.
For SARFACI. IDB, it's slightly different. But for SARFACI,
SARFACI matters.
It is a SARFACI, but lordship is absolutely SARFACI. It has to be interlocutory order.
We are on SARFACI. Let us stick to SARFACI.
I'm sorry.
Well,
2020, and it was a case where a sale was challenged. Auction was sought to be stayed. That was rejected. Against that DRT, against that DRAT, then probably Bombay or Delhi, and then the
My lord, absolutely correct, my lord. I'm not standing on that way. My lord, my prayer before your lordships would be that, my lord, power is there under statute.
power is there, but there has to be material. There is no material.
So, depositing, pre-depositing means 50%, my lord, would be a
You have not been able
tremendous
to
hardship for
satisfy.
a person.
You have not been able to satisfy the DRAT on that ground. And in any case, whatever you want, if you want consideration, that order is there, because the DRT, as you showed, it says that you go and the bank will decide. Bank will in any case decide. Whatever the banks decide will again be amenable to challenge, if you want to challenge.
What bank has decided, my lord, that's not a normal scheme. But what I'm talking about, what I'm praying for,
No,
my
in
lord,
this also, the impugned order, which page is there? The order impugned before
271. Volume 2, volume 271. 20th of March 2025.
Let the bank take decision. He has written that the bank has take.
That is under, my lord, normal scheme.
Whatever.
Under normal scheme, if I ask,
it doesn't say, the DRT doesn't say normal scheme. DRT says bank will take decision, and if it isn't a scheme or not scheme, you still have a chance.
I had a chance, since, my lord, that was not even disclosed by the bank. The scheme is prevailing.
That is on merits.
That is obviously on merits, but in merits, on merits, my lord, I have a very good case to establish. Only my difficulty and hurdle is that the amount that they have claimed. So for a common person or a company, a single simple company, and it is not that for the first time, my lord, I am asking for. On repeated occasions, my lord, I urge for that.
On what basis can you get this direction that you can go back to DRAT to pray for it? Because there is no provision for review in any case of the order.
Review is not there. That's why, my lord, I before your lordships, my lord.
I cannot change the facts. Your application I cannot change. Your application is there on record.
My lord, in applications, only one portion is that in accordance with law, pre-deposit under
Law will not do. For waiving it, facts have to be there. Law gives the power.
Yes.
The exercise will be on the basis of facts. Facts you will have to give.
Facts, my lord,
Facts
that I
are
have
not there.
provided by before the tribunals, that the annexures and the documents.
In the waiver application, there is nothing. That has to be there.
That was not there. But, my lord, when I file an waiver applications followed by my appeal, I relied upon documents from my lord appeal.
That doesn't is it's not apparent also. This revisional application.
Well, I am appearing led by Mr. Moinak Bose, my lord. My lord, this is an eviction suit, my lord. My lord, I am for the, my lord, tenant defendant before your lordship. My lord, in the suit, my lord, the dependent tenant, my lord, filed the application under Order 14, Rule 2 of the Code of Civil Procedure. My lord, kindly read out the, my lord, the impugned order, my lord. My lord, the record is taken up for passing order upon the application. My lord. I start impugned order.
ठीक है judgment purpose CHN judgment purpose what is this did take out the CHN Bench CHN tada I'll tell you, Lordship.
Cite the landlord-tenant issue relation.
Yes, well, the only problem I'll tell you, Lordship, as your Lordship is seen from the facts, I say I don't accept him as a landlord. So my 7172 filing of 7172 does not require.
Not required, but since he has filed a suit for eviction on the ground of landlord-tenant dispute, therefore this relationship, whether it exists,
Absolutely, absolutely. No, correct, correct.
and this issue has to be decided. He has said he'll decide the issue.
No, only difficulty is that your Lordship will see. I have filed an application for framing a preliminary issue under Order 14, Rule 2. Yes.
Who says that framing a preliminary issue under Order 14, Rule 2 will be in case if the suit can be disposed of. That issue can be framed, and it's not that the issue cannot be framed. He says he will decide the issue.
I'll tell you, Lordship, if 14.2 issue would be that whether a proceeding under the West Bengal Premises Tenancy Act can be initiated against the defendant relationship based.
Issue cannot be decided on pure questions of law. Then as a preliminary issue, it cannot be decided. The issue of landlord-tenant relationship, whether it exists or not, is
Yes.
a question of fact. Now, this issue will require evidence. This preliminary issue, adjudication, Order 14.
Yes.
Purpose of expedition, where we need not wait for evidence, like Order 7 at the threshold stage by seeing plain.
Yes.
Even up
In fact, instead of troubling your Lordship much, my Lord, this issue fell for consideration in several 56. As your Lordship is aware, 17.1, 17.2. Yes, my Lord.
All the authorities.
And my Lord.
Yesterday I was told that 95 Calcutta or 95 CH.
No, my Lord, thereafter what happened, my Lord, thereafter there was a division bench. All matters were referred to a division bench because there was a conflict. And division bench finally passed the judgment. My Lord, kindly takes this. This was the division bench judgment. Well,
kindly give me the citation, Moinak.
Yes, well, 1998, 1 Calcutta High Court notes, page 387. Well, kindly take the first paragraph.
answering the following question. My lord, kindly take the second question. B. First paragraph. Whether the West Bengal Premises Tenancy Act being a special statute and particularly 7(2) of the Act being a special provision in that statute will override and get precedence over the general provision of Order 14, Rule 2. Then, my lord, kindly come to paragraph. My lord, paragraph 20. Which is the part of Justice Bhaskar Bhattacharya's judgment.
Last page, Mr.
Well, that would be the part of Justice Gupta. Well, there are two parts. This is the concurring judgment. Well, if your lordship will see first the Justice Bhattacharya's part of the judgment, if I just trouble your lordship with once, kindly take para 20 and turn it to the next page, 396. About, my lord, 6 lines from the top, there is a paragraph starting, there is no doubt that in view of 29(6) of the Act, the Code of Civil Procedure applies to the suit for eviction, since the aforesaid provision Order 14 is merely a procedural part of the code. Then this continues. It is in no way in conflict with the decisions of the court to hear an issue on the fact. As preliminary issue, in our opinion, there is no substance in the contention of the advocate for the petitioner that the net charger acted without jurisdiction in deciding a particular issue of fact as a preliminary issue. Then, my lord, kindly take para 22. A is the answer to the two questions which were framed.
That is exactly what
Yes,
I said.
yes, yes,
It decided, but
yes.
it cannot be disposed of. So if your issue is, that is what it says. Suit must not be decided.
Correct. The other issues, basically, it will follow suit.
That is what the trial court has.
Now, my lord, lordship was referring to Justice Gupta's part of the judgment. Kindly, my lord, take that. My lord, your lordship wanted to was referring to para 6.
Just above para 6.
Yes, my lord.
Well, thus we find a complete dichotomy between the two situations.
But I haven't been able to follow your lordship, my lord. Para 5.
I think we are not sharing the same data.
Not sharing the same. So what have you given? Sorry.
I have marked the pencil.
Yes, my lord, I've understood. Applying the aforesaid, correct? There, thus. Yes, my lord, I'll find. Where is it there? Yes, there thus we find the two situations in Order 14, Rule 2 itself, one permitting the court to take up for consideration and decide preliminary issues, both on fact and law, but not disposing of the suit on the basis of its finding on these issues. And the other permitting the court to take up the preliminary issue for consideration, but confining it to restricting itself only to such issues which are pure issues of law, and also additionally permitting the court to finally dispose of the suit on the basis of the findings on these issues.
You fall in the second part. Because in your case,
yes,
it is not a pure question of law. Therefore, suit maintainability probably cannot be decided at this stage.
Mother, we say it is a pure question of law because then I have to tell you, lordship, a little bit of the fact.
Evidence.
This person who has instituted the suit is the transferee landlord.
Without evidence, it can be decided.
Yes.
Without evidence.
Without evidence, because it is an admitted fact. What is an admitted fact? No further evidence is required. Now, the situation is he is a transferee landlord of 50%. So I had joint landlord, A and B. B was a trust. Now the trustee of the B trust, who was the half share, individually in her capacity as not as a capacity as trustee, individually sold her portion to the present plaintiff, and thereafter she died. Now the present plaintiff says that I have purchased a demarcated portion. So which is inconsistent with the conveyance by virtue of which is derived title.
But then this will require evidence. It can't be absolute question.
Well, possibly some evidence maybe.
Yes.
Well, but evidence in order 14 rule 2, if
No,
court
if it
wants,
is a-
the court can take evidence.
Yes, but if it requires evidence, it has
Yes.
to wait till trial. If it is only preliminary issue, pure question of law, because that was settled, I think, Nusli Nevli Vadia.
No, my lord, there is a recent Supreme Court judgment which says there is no bar in law in taking evidence if the court thinks to decide a preliminary issue, evidence is required to be taken.
I found
Limited evidence can be taken.
in some case while I was doing, I had come across the Justice Arun Mishra's judgment and large bench, where it has been said that no, if it is a mixed question of law and fact, then it cannot be decided for the purpose of disposal of the suit as a
Now the
preliminary issue.
interesting part is that, my
For
lord,
example, limitation. In many cases, it's a pure question of law. In many cases, it's mixed. Wherever it is mixed, it can't be taken up as a preliminary issue, and that was the question which was
so
decided.
then, my lord, if the court wants to decide this as a 7-3 situation, because
the court has said that I will decide that issue also, which is why I say, otherwise I would have interfered. If you read the just the last 4 lines of the penultimate paragraph, rather the paragraph above penultimate, if we read that 1-line paragraph as a paragraph,
give it to me.
just above, hence
Mine has
the
got
application.
stuck. Mine has got stuck.
Page 4 of the impugned order.
Yes, sir.
Just above, hence.
Yes, my lord.
However, it is made clear, just 3-4 lines above, hence.
That the issue of landlord-tenant relationship shall be taken up along with 7-3 application
that issue also.
as mandated by the division bench of the High Court in the case of synthetic plywood, which is synthetic plywood, which is the other judgment, my lord, of synthetic plywood is, just give me the synthetic plywood judgment, 98-1 CHN.
Yes, that is what.
This is the one that we are referring to.
Yes, so he in view of this, he will be deciding the issue.
Yes.
It is not that he is not deciding it.
Yes.
That is why I said there is maybe the language which he has used is unsavory, but ultimately your purpose is served.
Yes, but then kindly clarify this situation that, my lord, the issue of landlord-tenant has to be decided before striking, because striking out defense under 7-3 is a consequence of 7-1-7.
Has to be. If a person is not a tenant, he cannot be thrown out by a side wind of 7-3.
And because he has not filed 7-1-70, in fact, there's a Shonji Banerjee judgment.
He's not required to.
Correct.
He's not required to file 7-1-7-2.
In
If I say I'm not a tenant,
Right.
I'll not file 7-1-7-2. I'll just file my written statement, say that you please proceed, because I'm not worried about any default
But
or.
kindly clarifies that position. That should be sufficient. Grateful.
This revisional application is directed again Yes, Mr. Banerjee, you have anything to add?
My lord, I could not hear the dictation because time of dictation it usually.
I have only dictated whatever Mr. Bose submitted. You want to submit anything?
No, my lord, not really anything. My lord, at the 7-3 stage, they are entitled to, of course, challenge the landlord, and that lordship has clarified.
Very good.
I'm deeply obliged.
Mr. Banerjee, a learned advocate appearing for the opposite party, submits that the learned trial court has committed no error in observing that the issue as regards landlord-tenant relationship shall be decided along with the application under section 7 within bracket 3 of the 1997 Act. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. Paragraph. It is now well settled that the scheme of the West Bengal Premises Tenancy Act, it is now well settled that going by the language of the West Bengal Premises Tenancy Act, the wrath of section 7(3) of the 1997 Act heard only by a tenant and none else. It's for this reason that the statute expression tenant and not the defendant. Full stop. The provision of section 7(3) would be attracted only if the defendant is a tenant and not otherwise. Full stop. The Honorable Division Bench of this court, in the case of synthetic plywood industry Sutra, has held that while a suit may not be decided on the basis of decision on the issue as regards landlord-tenant relationship, if negative, without pronouncing judgment on all other issues, yet, such issue can always be decided as a preliminary issue. Full stop. Paragraph. In such view of the matter, since this court finds that the learned trial court has held that the learned trial court would decide the issue of landlord-tenant relationship, the same cannot be faulted. However, it needs to be clarified that the issue as regards landlord-tenant relationship must be decided prior to a decision being taken on the opposite party's application under section 7(3) of the 1997.
I'm sorry, my lord. Usually not prior to. Usually, if it is prior to, then it becomes two separate proceedings. It is along with.
No. It is always prior to, because that issue has to be decided only then 7(3) will apply. Application of
that means both the two issues are taken together.
Has to be prior. Has to be prior. It may be on the same day, but before decide.
Yes. If your lordship can.
That is what is meant. I decide to strike out defense and then I decide landlord-tenant relationship.
Yes, lordship.
With the aforesaid observations, CO 4599 of 2025 stands disposed of. There shall be no order as to costs.
Oblige, your lordship.
I'm deeply obliged.
Yeah. 12:30 ना? ठीक है. Yes, Mr. Ghosh, before the vacation, we'll do this. Will we do this before the vacation or we can have it after the vacation?
One thing, my lord, we have filed already a revision application against the order allowing the section 5 that is sketchy and non-speaking in character. So I want to challenge that order. This revision application may be appeared along with this.
The
order passed in 2017.
Not a problem.
But without jurisdiction order, procedural.
Explain your delay properly.
Well, I have one judgment, but procedural.
But even then, you have to explain the delay. Very.
Well, the earlier order, this order could directed to hear out the matter of 71 minutes. That is already been proved.
Take that point whenever that comes.
The 24th June.
Today we are not hearing it. Today we are not hearing it. We'll hear it.
I do not want to open my mouth. Revision application itself is unmaintainable because there are 7 defendants. One defendant cannot challenge the order.
Very well.
Absolutely
Let
not
us see. We'll have it after the vacation. No, after the vacation. Yes.
On 9th.
9th.
Item number 9, Your Lordship, I am for the petitioner. Lordship kindly sees the interim order, what has happened. Ex parte ad interim order was refused. He preferred an appeal before the appellate court. Interim order was passed. Thereafter, there is a violation of interim order. We have filed an application for compliance of the interim order. Now, the trial court said that if there is an order 39 rule 2A, there is no scope of granting any relief under section 151. And on that basis, Your Lordship, application has been dismissed.
Yes.
Well settled principle of law, Your Lordship, it has to be.
Why this?
So the additive order of injunction.
Even then.
My lord.
51, why not?
Pardon, my lord.
Why not 151 for implementation?
Implementation. 151, my lord, this came up for consideration before this honorable court also. Coordinate makes a category head.
There are.
No, after that, my lord, we are led upon this 2025 SCC online. The last. 736. Yes.
Because long back, Your Lordship, this issue was decided that it has to be decided whether Your Lordship is requirement or there or not. But only order 39 rule 2A, my 151 will be dismissed. He was 40? Me are asking, correct?
In view of the, it has to be adjudicated. 44. Now, I can consider what is the allegation made and on what basis it has been done.
So that is required to be adjudicated. I can show Your Lordship.
No, if it has not determined the rights at the ad interim stage,
yes,
then it can be done. Show me from the interim.
Yes, yes, Your Lordship. Lordship, kindly allow me, Your Lordship. Then.
Yes.
Lordship, kindly see, Your Lordship, the interim order, Your Lordship, which has been passed, page 34. The appellate court, Your Lordship, passed an order. Lordship, kindly sees the reasoned order. And thereafter, Your Lordship, the interim order has been extended from time to time. So may I just place it, page 34?
Yes, so, Mr. Rai, there is a specific finding that he is in possession.
And thereafter, Your Lordship, I filed an application.
Finding that he is in possession. If there is some such sort of a decision, he will wait till conclusion of order 39 rule 2A.
And this order is not under challenge.
Now, if there is an additive order of injunction, there are 2 courses open for party. One, to file an application on 39(4) or to contest the injunction application. I have participated. Now, my lord,
or to prefer appeal also.
Or to prefer an appeal.
Or in this case, since
revision.
Appeal revision.
Here. Now, my lord, additive also, I have to participate there. Filing objection, I can serve the same. Now, my lord, at this stage, what is the findings regarding the?
There is a finding.
Yes, my lord,
just above the ordering portion.
The interim order of the appeal such as such, the respondent one is restrained from causing any kind of obstruction.
No. Mr. Just above the ordering portion.
On perusal.
The plaintiff appellate is position of the Supreme.
Yes.
This is the case in his favor. The balance. Now, I can turn to the order 151 application.
If he is in possession, why it can't be done?
And file a police complaint also.
Yes.
That has to be adjudicated.
I
mean, who's in 151?
Para 5, 6, Your Lordship, the explanation I have given.
Along with main agent, disconnected the electricity connection as well water connection to the suitability who is basic necessity of life and is criminal offense on raising the human cry. So this on the premise this application has been filed.
And police complaint, Your Lordship, kindly sees, Your Lordship, this I have annexed, page 38. ঠিক আছে হয়ে আসুক না ডিসাইড তো হতে হবে
And what was the facts in this case?
Yes.
The one which you have cited?
আমরা will also rely on this one এই তো আমার দেখ না এটা দাও দীপঙ্কর
তো সেই মামলাটা 4 paragraph 4 in connection with the efforts to opposite party number 1 and 2 file an application 13 and 1 and 2 with this civil procedure for temporary injunction restraining the petitioner and the maid and agents from causing any obstruction in the day-to-day affairs of the running of the hotel business and the management of the petitioner one company. As upon hearing the plaintiff opposite party number 1, 2 and 1 and 2 hearing, the learned trial judge passed an order such as thereby restraining the petitioner and the maid and agents from obstructing the running of the hotel business over the suit civil property by the plaintiff opposite party number 1 and 2 till October 24, 2025.
He has not even heard the 151 application. He has said you file order 30 and dispose it of on merits. If he had called affidavits, he had heard it, that would have been a different thing. This was a case where it was
What we do,
affidavits were not called. He cannot just shirk off his responsibility saying you filed, I will not hear 151. That cannot be the law.
Ultimate conclusion, violent can supply the reasons. If the conclusion is
No,
correct.
but after hearing, he cannot, he has not decided anything. Reasons, if
Just
he
like a
doesn't hear
non-maintainable.
it, let him hear the application.
That is
first.
why, my lord, in the similar circumstances, this honorable court categorically held
I'm grateful, Your Lordship.
that
Let him
Your Lordship.
yes, all are considered.
Long back.
All the
That
judges
we are asking it is not possible. You have to establish. So establishing, Your Lordship, has to be
that
done
has
by
to
the
be heard.
Yes, Your Lordship. I'm grateful, Your Lordship. আপনারই করা নাকি জয়দেব দাসটা
না জয়দেব দাসটা আমার না
Justice Jyotirmay Bhattacharya's judgment, earlier one is there where it has been allowed.
Yes, yes, additive order injunction that was also been placed here also. My lord will file. Sheikh Bilal, if I am not.
The facts were very telling here. The facts were very telling here. The plaint case showed doubts as to whether he was in possession or not. Here there is no such doubt.
Here, my lord, the order of injunction, my lord is concerning the.
I am not going to go on merits. Let him hear it.
I'm grateful, Your Lordship.
That's it. This revisional application.
Ten, your lordship, I'm paying for a small parcel for your lordship.
Passed over.
My lord, yesterday matter was called on, my lord.
My lord, Mr. Shorkar, my lord, he's in Vellore, my lord, due to some medical emergency.
Very well.
My lord, I'm suffering with the identity order. My lord, this is the case. My lord, your lordship heard this matter, and my lord, in spite of lodging caveat, my lord, there is a checkered history. My lord,
Yes, madam, if there is lodgement of caveat and somebody
Yes.
is
ignoring that, my lord, the trial court refused to grant interim order on the basis that mutation application was cancelled. My lord, and my lord, fraudulent act was done, FIR was lodged. My lord, on that ground, since my name is appearing in the record of rights, considering that my lord, interim order was refused. My lord, in spite of my lord caveat, it was noted in the my lord order sheet, no caveat has been lodged. My lord, thereafter, my lord, the opposite party number one preferred my lord, first appellate court. But appellate court, my lord, without considering anything, my lord, granted ad interim order of injunction. I am suffering with that. My lord,
if he says he's in Vellore treated, what to do? We can have it immediately after.
my
the
lord,
vacation.
my problem is not, my lord, due to my lord, ad interim order, my lord, position is being disturbed by the my lord, the opposite party number one. There, my lord, I am praying only for ad interim, my lord, interim order stay for limited period, my lord.
You're there.
My lord, I am, my lord,
Supporting-
the opposite party number two, virtually supporting the.
Yes, I got property from.
I have sold my right to the
Yes,
plaintiff.
without
My lord,
caveat, this is becoming very difficult. You please make arrangements, otherwise I'll have to stay the order.
My lord,
For limited period, my
immediately
lord.
after the vacation, my lord, he'll be back.
For 2 more weeks, what will happen? Because he's in Vellore, I don't want to.
My lord, yesterday night, my client came to my chamber. My lord, what is my problem? My lord, 2022, I purchased the property. When I tried to get my name recorded, I got that name of the my lord, opposite party was recorded, and I filed a miscellaneous application before the my lord, BLRO. BLRO he contested, and BLRO observed that deed produced by the opposite party is fake and fake, my lord, fraudulent. Against that, one FIR was lost. Suppressing anything,
Madam, you please tell your client to make alternate arrangements.
interim period of stay, nobody will be prejudiced.
I have very little less to say. Will you kindly see this is an challenging and ad interim order of status quo passed in appeal. Will not appeal is pending. It may be directly to be disposed of.
Well, the problem is this.
He wants
Setting aside, I wanted to take the maintainability of the before the suit court. Suit is is the nullity because no cause of action.
That observation
I will take this point, my lord. I will take this point unless the order is
here.
Unless the order of the appellate court is set out.
This case is that he had lost caveat and yet interim order was passed. That is in one of
Well,
your
this
cases.
is a new trend, Millard, which is coming, Millard. If
Madam,
the other court,
please make arrangements. I'm fixing it on Friday. Otherwise, I'll have to consider grant of interim order. Please make arrangements for somebody. I'm recording an order. Liken in.
Friday.
Your lordships will recall this is that matter.
Where is your other side? You haven't given.
My lords, we mentioned upon notice, my lords. We had mentioned upon notice. My lords, I'll just indicate to my advocate on record to just contact her. This is called for
I'm passing it over. Let's see if he comes.
my lords,
Because before the vacation, I'll not hear it. I'll just.
no, the difficulty I tell your lordship is on 8th of June, my suit is returnable.
I'll say that it will be adjourned to a later date, but that should be in his presence.
Then your lordship kindly does this. I'll just indicate your lordship passes it over. Then your lordship does this. Kindly, my lords, since I've filed my notes, your lordship has also recorded copious notes on the matter. My lords can either keep it on Friday, fix it, or keeps it after vacations, gives us liberty to pray for an adjournment before the trial court, and my lords kindly marks it as part heard. My lords, I tell your lordship, my lords, we've spent quite some, my lords, 3 days we've argued the matter. Your lordship will kindly do that, my lords.
Argued for 1 day, 3 days date.
No, my lords, 2 days at least I've argued, my lords. Kindly, my lords. That is one prayer I would insist on. My lords, re-arguing the entire matter again.
It will be there in the list. Chalo, pass over.
I'll just indicate to my other side.
Game for a small Passover, you
Passover again. Chalo, next.
Wait to appear for the
Item number 13, my lord.
Please wait now. 14 has been called.
14, but I am for the opposite.
Yes, there was a liberty given to file a supplementary affidavit.
Yes, annexing that order.
He the supplementary evidence কি আছে?
দিচ্ছি কবে দিচ্ছি
দিন আমাকে একটু দিন।
শুধু আগের লোয়ার কোর্টে দুটো অর্ডার করেছে আমার ক্লার্কের কাছে আছে আমি দিচ্ছি
Yes, sir.
Lord, the suit filed by the son against the mother, widow mother. Lord, kindly see the age of the suit. Since 2007, Lord, the property, Lord, the litigation is going on. Lord, because of the Lord, the apathy on the part of the plaintiff, the matter is pending. Lord, what happened here? The father is the recipient of his land from the RR department. Father has transferred this property in favor of the unmarried sister, who is the defendant number 2 in the present suit. Lord, since 2007, the suit has been filed and he is not taking any endeavors to reach the logical conclusion of the suit. Lord, each and every day, Lord, for commission, Lord, if I submit all the orders before your lordship, 4 to 5 years, the commission order matter was pending for commission's order. I'm not. This application is nothing for only for the prolonged litigation and nothing else.
Lordship, this is the last witness we have, and this order, this commissioner needs to be appointed because he is a bedridden person. Otherwise, he could have come to the court. This is the last witness we are having.
Prescription has been given.
The prescription has been given, Lordship, in the application.
Show me that what material you have shown before the trial court to justify evidence on commission.
If I have the
Page 35 is the application, Lord. No materials was placed. Even Lord, the name of the patient and the name of the
name ultimately after examination only the real name will come out. But for that, commission could not have been denied.
So, Lord, Lanet judge has held that he produced a prescription. The name of the patient of that prescription and name of the person who shall be proposed to be examined are not tallying.
In the application itself, we have indicated that both are a same and identical person, Lordship.
Where is that?
It is,
Yes, Ratan Guha alias Dilip Kumar Guha.
Page 36.
Yes, he says he has given both the names. What is the problem then?
Plus, they do not kindly come to observation of the learned judge.
Yes.
The middle portion.
learned advocate for the defendant raised the objection, strong objection and submitted that from the prescription filed by the plaintiff, it cannot be seen that the concerned person has put his signature and said signature has been identified by the concerned doctor. Accordingly, it cannot be taken into consideration. Moreover, there is no evidence on record that the Ratna Guha and the Dilip Kumar Guha are the same persons. The plaintiff has filed the instant petition in order to cause the unnecessary delay in the suit. Hence, the prayer of the plaintiff made in the instant petition is liable to be rejected. Heard the both sides, peruse the record on carefully. During course of the hearing, it appears the plaintiff is
Yes, sir. What is there to show that they are the same persons?
Lordship, that is why, Lordship, we need to commissioner to be appointed.
Why?
Lordship,
you have to be sure which person you want to.
Both are same and identical person.
How? Something must be shown.
Yes, Lordship, there is a prescription that is not
that
with me right now.
prescription is in the name of some person. That does not mean that the same person has another
Lordship,
name.
on that application, we have mentioned it previously. It is not during the course of the hearing that
you had mentioned in the application, but with the application also you should have furnished at least some something.
Lordship, the trial court hasn't asked for any clarification or rectification.
Not required. You will not furnish clarification upon the trial court's requirement. You will furnish clarification for the purpose of the standing of your application, so that your application stands. You won't provide legs to your application, then how will the trial court consider it?
Bhudev Chatterjee is appearing in this matter. Kindly fix it another day.
When is the date before the trial court?
10th June.
That has to be after the vacation.
After the vacation.
Lord, mother has filed a suit for eviction against the son by way of the counterclaim in the present suit.
Very well. Ask him to come.
Lord, under compelling.
एक minute. लिखे नहीं. An adjournment is prayed for on behalf of the petitioner.
Time. I understand. I was following your lordship's court. I know that Thursday your lordship has fixed several matters. Plus Friday.
There is an upgraded matter wherever it is.
Let it retain his position in the list.
Item number 10, my lordship has passed it over.
Item number 13, my lord. Don't mention like this.
Sorry. I apologize.
Please call করুন একবার 13 এর আগে তাহলে 10 কল করে দিন
10, I'm for the petitioner, my lord.
Where is the other side?
Where I have served, they have been communicated yesterday night also. I have informed them. In fact, they have written to me asking for this petition. I have given them copy. Lordship's order has been complied. First call is low. But today they are not. Oh, in the morning also we have intimated that matter is because we mentioned it on notice. Then it came in the upgraded motion, my lord.
Mentioning notice was also given.
একটা order record করে নিন।
But kindly stay the proceeding. 22nd is the next date.
Before that, I'll finish the petition.
Kindly, 22nd is the
None appears for the, where is your service?
This is the my lord affidavit of service. My lord, my application filed under order 26 rule 9 has been rejected by the learned trial judge only on the premise that the defendant opposite party has admitted the ownership of in regard to the suit property, my lord. If your lordship kindly come at the page 25, that is the plaint.
Page 25.
Yes.
Yes.
Paragraph number 8. That is the specific averment which has been taken by the.
When is the next date in the suit? I don't want to do it ex parte. When is the next date in the suit?
My lord, it is 8 June, my lord.
None appears for the
Action is that, my lord, the petitioner herein, my lord, is not the tenant, my lord.
is a trace. So therefore 7172 will not
is
apply.
not applicable.
I'll record that.
Yes.
But in the event the suit is for not for the not against tenant, and my lord, for the he has my lord, I have said
So if the suit is not for eviction of tenant, he says so. If the
According to your law-
717273 does not apply to you, your defense is not going to be struck.
clarified it that I am
Lord, your
not
lordship knows, my lord.
suit is
You are-
for eviction of a trespasser.
According to section 2G, my lord.
He says section 2G.
If it is a his case,
You
my
will,
lord,
I
he
will,
has
I will, I will,
stated-
I will record that. Your defense will not be struck out under 7.3. That's it. That saves you. That serves your purpose. That was your only worry.
Affidavit of service, my lord.
Hmm. 16, Lord, I'm for the petitioner. Lord, this matter was, Lord, he's taking up urgent matters because of urgency. That court has passed an order. Now it was made returnable, but it has appeared as an upgraded motion. We have not mentioned for upgradation. I was saying, but today I'm not ready. Kindly take up after vacation. Immediately on reopening, kindly take up, my lord.
After vacation করে দিন
I'm grateful.
দিদি
Affidavit of service, I have filed, my lord. My lord, affidavit of service, I have filed.
ফাইল আচ্ছা লিখে দিন দেন
I have filed.
অ্যাফিডেভিট অফ রিটার্ন করে দিন না ফালতু ফালতু অর্ডার দিয়ে কি হবে আফটার ভ্যাকেশনের অর্ডার
We
দেওয়ার
shall
কোনো মানে
file on the next day. We shall
Yes,
we shall
yes.
file after vacation on the next.
let the matter be adjourned after vacation how will it look and then I'll record your
Since I am already
petitioner.
appeared, only for keeping the record. I'm good.
হ্যাঁ
No?
মেনশনটা কে করলো তাহলে why did you mention
I mentioned
The matter. I have not mentioned the matter, my lord. It is a
We have not-
surprise.
It was made returnable on 15th by the other bench, possibly. That is why it has come, my lord. The other bench, subject to your lordship's convenience, let the matter be made returnable. That was the order. That is why possibly it has come.
Matter, Tarok Dotto, not this matter, my lord.
তাহলে
But the matter is Tarok Dotto. Probably
নামগুলো
number.
মেলাচ্ছেন না কেন
Probably
নাম্বারে যাচ্ছেন কেন বারবার বারবার তো বলি নাম মেলাবেন এই একটা
Probably another matter is mentioned.
No, it is of 2025.
Number.
1320 of 2025. নাম্বারটাও ভুল আছে।
নামটাও আলাদা আমার
It is 226.
আমার তো 26
আমরা অ্যাপিয়ার করছি
যখন লিখে যাচ্ছে নাম্বারটা ভুল লিখে দিয়েছে।
আচ্ছা
তো
হ্যাঁ
the wrong file is.
কেন এরকম ভুল হচ্ছে দিদি প্রত্যেক দিন আপনারা ভুল ভাল ম্যাটার তুলে দিচ্ছেন ওইটা সেটা আমি জানি না আপনি ওইটা ঠিক ম্যাটার তুলবেন যার নিয়ে নিয়েছেন
Well, in this matter, I have the instructions to appear on behalf of the opposite party.
Worship, the urgency in this matter is that this arises out of an application under section 25 of the Guardians and Wards Act, wherein I am the mother. My lord, at the instance of the father's application, my lord, the mother's right to visit the child has been stayed. My lord, the 13B application has been pending, my lord, wherein it is admitted case that the custody of the child was shared. The custody of the child is it's a girl child for 5 years old. The custody of the child, my lord, is that in the weekdays the child used to stay with the mother, and in the weekends the father used to take the custody of the child. On the day of Saraswati Pujo, my lord, some of the relatives of the father took the child for a lunch, and after that, my lord, the child was taken to the father's custody, and my lord, thereafter I was not able to contact the child anymore. And I preferred an application, my lord, under Domestic Violence Act, and in the Domestic Violence Act, custody was granted for 3 days. That was registered, and thereafter, my lord, the father has obtained a stay in respect of the domestic violence, my lord, order. In the meantime, and my lord, a vacating application is pending in respect of that. In the meantime, my lord, I have filed, my lord, the father has also filed an application under section 25 of the Guardians and Wards Act. And therein, my lord, an ex parte ad interim order has been passed restraining the mother, my lord, from having any contacts with the child. And the interim order is till 8th of June. My lord, at this point, my lord, I only pray, my lord, that the mother be allowed, my lord, an arrangement be made so that the mother can see the child.
My lord, may I submit?
problem in that
My lord, in the year of 2017, the marriage took place. In the year of 2020, the girl child was born. My lord, the parties parted in the year of 2024. Thereafter, a mutual divorce application was filed. My lord, when my daughter was in the custody of my wife during the pendency of the mutual divorce application, my lord, the male acquaintance of my wife, my lord, committed an aggravated sexual assault on my child, which was reported to me. On the basis of the same, against the male acquaintance of my wife, my lord, a case under section 6 of the POCSO Act was registered with the Netaji.
Just a moment. Didi, YouTube বন্ধ করো। Yes.
My lord, after the said incident was reported to me by my daughter, my lord, who is a minor, aged about